Hello everybody, welcome as always to the Friday afternoon webinar from Hines Legal. I'm your host, Chris Hines, Strata advisor, former commissioner for body corporate, blah, blah, blah. With me as always, Frank Higginson, partner at Hines. Frank, welcome.
Hello everyone. Thank you.
And very pleased to have a special guest speaker or special guest appearance this week from Antonia Mercorella. Antonia is the CEO of the Real Estate Institute of Queensland. Antonia, welcome.
Hello, great to be with you both. Thanks for having me.
Particularly great given that Antonia is our first quote unquote external guest speaker. So happy days, and all the technology is working, which is even more exciting. So that's a good thing.
And unusual.
Yeah. Just a quick note to everyone watching, please remember to like and share far and wide. You can ask questions today, so pop a question onto the Hines Legal Facebook page and we'll get to as many of those as we can in today's session. Antonia, I might flick to you first, because this week we're going to talk about real estate agents in Strata, one of the more tricky areas. There's a lot of tricky areas in body corporate law. This is one of the tricky ones. Before we get there though, for people who don't know, tell us a little bit about the Real Estate Institute, Antonia. What does it do? What does it represent?
Of course. Well, the REIQ is the peak body for real estate in Queensland. We represent real estate practitioners, and of course, that includes a broad range of sectors, resident letting agents, salespeople, commercial and industrial agents, residential property managers, auctioneers, and of course business brokers and buyers agents. So really quite a broad spectrum. And really our role is to, we are a membership body where it is voluntary to be a member of the REIQ. Often the public misunderstands our role and believes us to be a regulatory authority, which we are not. And similarly, sometimes we are seen as being the licensing body, which we are not. So we are a membership body. But of course, one of the things we do that is incredibly important is that we advocate for change, for legislative settings and regulatory settings that we believe are advantageous and will enhance the process that is real estate, that make real estate transactions easier. And really, I think what's become apparent, particularly during COVID, is just how much centres around real estate in our local economy and in our state. And I think really shelter at the end of the day is just such an essential part of who we all are. So I see us as having an incredibly important role in the Queensland community.
I mean, it's interesting you say all that, Antonia, because it's a point that Frank and I make a lot as well in the body corporate sector, that you can talk all you like about the money involved and the legalities and the regulation, but at the end of the day, it is a person's home that we are talking about, and that is front and center of people's thinking. And so then that leads us very nicely, he says, segueing into what we're talking about today, which is that overlap between real estate and body corporate issues. Frank, you'd know from your years of experience that it's a tough one to navigate sometimes.
Always. And I think probably, as Antonia was saying, and agree, property is the center of everything we do. You know what I mean? In terms of when the GFC for me, and probably a little bit COVID related in April, but the GFC, when property transactions stopped, everything stopped. All business activity stops. We're all hinged to the value of our property, the security in relation to it, banks' willingness or ability to lend on it, our ability to get funds from it, ability to realise it, to invest in other things. So, and then I suppose you come down a level, and mate, it's the same stuff we talk about every week, where people just don't understand where to go, where to turn. And so that issue of real estate agents dealing with body corporate managers and understanding how management rights works and all that sort of stuff can be complex, and it's not as easy as just picking up a phone sometimes and here we go, let's solve this problem. There's processes and all that sort of stuff, which is really what we're talking about today.
Antonia, how well do you think your members sort of grapple with the strata issues they face, regardless of whether it's leasing or whether it's sales? How do you think your members engage with body corporate issues?
Look, I think it's an interesting question. If I'm honest, I think it's an area that is still a struggle for many. And I think many find it challenging. It is quite a complex area and it's not always well understood. And indeed, you know, what we have seen, I mean, this is one of the reasons why we do a range of education around body corporate issues, because I do think it is quite a unique landscape. Quite different. And so, you know, it's our job to make sure that we're keeping real estate practitioners updated about how the laws in this area are changing, what the unique requirements are. And I think the punter on the street doesn't always understand this landscape. And often it is left to the real estate practitioner to do that education of the average person on the street. And it's not always understood. You know, what is the difference? Because I think it's a relatively new way of living here in Australia, and I think it's an issue that I think really education is essential, and I think this is going to be becoming more and more common. This style of accommodation in Queensland and in Australia more generally is becoming increasingly more popular. So I think educating people about the uniqueness of this landscape and real estate practitioners is really critically important.
I mean, I agree. I know that in my former role, one of the things that I saw a lot, and I think was at the heart of any kind of misunderstandings here, and I'll get you both, Antonia and Frank, to speak to this one, is that the way in which real estate and strata responsibilities are set out is quite different. For a real estate agent, their primary responsibility is to their vendor, first and foremost. And that's enshrined in law. That's not just a commercial reality, that's a legal reality. From the body corporate's point of view, they have a slightly different focus, don't they, Frank?
Yeah, they've got to act reasonably. They've got statutory obligations to keep common property in good repair and condition. Committees and bodies corporates have obligations to act reasonably, so they can't be I suppose, difficult just for the sake of it. And I suppose your former office, Chris, would be where you'd go to ventilate those concerns to the extent that you didn't have them. But, you know, and I suppose I'm not an academic lawyer in that sense, but, you know, a real estate agent has the same relationship to their vendor as what we do to our clients in terms of its fiduciary one. You must put your client's interests ahead of yours at all times. And in body corporate, there's not quite that same standard. There's this obligation to act reasonably, but and we see it all the time, mate, in terms of conflicts of interest and people voting and participating in decision making where they shouldn't be. When if you put that in a real estate agent or a lawyer sense, you'd almost be disbarred or struck off or lose your license for some of the behaviour we see at body corporate level. So, but by the same token, committees are volunteers. You know, so the bar is set higher for industry professionals. We're trained, we're qualified, we've got standards to uphold and all that sort of stuff. The moment, and this is, I suppose, another webinar we could do at some stage, is compulsory training for committee members, which comes up all the time. The moment they do that, we don't have committee members in Queensland. So the government's obviously seen fit, legitimately, to encourage people to participate in their own management of their own body corporate affairs. And sometimes the standards aren't necessarily what I suppose the three of us would otherwise expect to see in a professional services capacity.
Yeah.
Sorry.
No, I was just going to say, Antonia, I remember going to a training event when I was in my former role at the REIQ. It was a really good discussion that day. We spoke to a whole bunch of leasing agents, property managers, and a question came up from somebody in the audience, which I think really highlights this issue, which was, well, there's a problem at the body corporate with water ingress, and is it my role to be advocating on behalf of my vendor, which is the landlord in that case, to get a result with the body corporate? And there were some really diverse views on that in the room. We had some people who said, absolutely it is, that's your vendor. If they've got a problem with water ingress and they're not getting anywhere with it, with the body corporate, you should be in there advocating for them. And then there was an equally strong reaction from others saying, but hang on, that's their role as an owner. And if you're devoting time to that, you can't be devoting that time to your other clients and vendors either. It's a tough one, isn't it?
Yeah, it is a tough one. And I mean, I think those sorts of, that experience is fairly common. And again, I think it is in this area that there's a lot of confusion about where your role begins and ends, and I think it is far more complex than, say, a freestanding property at 5 Smith Street, where those sorts of issues tend to be a little bit more black and white. And I think the confusion, though, doesn't just stop at real estate agents, to be fair. I mean, I think even if, you know, we'll often hear stories about people buying, they go to look at an apartment or a unit, and often there's this question that's commonly asked about, well, how does this body corporate thing work, and how do I get out of it? I mean, I think that's an issue that I think we need to address, because I understand that consumers, that the buyers and sellers may expect it's fair to expect a real estate practitioner's knowledge to be superior. I think that's a reasonable expectation, but equally, I think if you're thinking about buying into a scheme like this, then, you know, I think there needs to be a certain amount of due diligence that you do to understand, what am I buying into and what responsibilities am I taking on? And I don't think it's enough to just assume that someone will hand you all of that information on a silver platter and you don't need to do anything to educate yourself about that and what the ongoing requirements are.
I could not agree more. And when you go to cut price conveyancing was the start for all of this way back when. We now have in Queensland a conveyancing protocol, which is this momentous document that is 40 pages long that you must, the advice you must give your clients is it's extraordinary in its depth, and you add CTS to it, community titles, it's even bigger. We almost send 50 pages worth of information to clients. We're required to as part of our insurance for them to get their heads around what it is they're buying, and effectively to cover our backsides as lawyers to make sure that we don't get sued when someone says you didn't tell me. But that's too much. You know, and to be fair, Antonia, I think probably what real estate agents are exceptional at is selling the dream. Detail doesn't sell the dream. When they're selling, they're selling this beautiful product, whatever it might be. People buy it, away they go, and then they get in, and then 6 months later they're going, what is this body corporate thing? I don't have to pay my levies. I've already paid my rates. Yeah, and
exactly. Which is probably a good moment to flick to one of our favourite topics, Frank, myth busting. We've got a few myths today to talk about with real estate and Strata. I might do a couple of my favourites to begin with. If the landlord has said the tenants can have a pet, that's all the approval that's needed.
Bom, bom.
We need sound effects.
we do need sound effects, and that's definitely false, that one. They're two completely different things. You've got the landlord, which is, and Tony, you can speak to this, it's a contract between the landlord and the tenant. It's one thing. Body corporate approval, whole other kettle of fish.
And mate, the one I love with real estate agents is not a single real estate agent that hasn't lost a deal because they've had a contract subject to approval of a pet and a body corporate said no. And body corporates just basically can't say no. Every agent you talk to has lost sales over that. That's my favourite one. Everyone I've met up here, Antonia, I tell that story to, that what?
Yeah.
It'll see the commission sailing away.
I think the issue of pets is such an interesting issue in this area, right? Because we know that pets are really important to us, and we know about the health benefits of it. And of course, we all know stories about pets and about blanket prohibitions against pets, or sort of rules around the weight of the pet and so forth. And we know time and time again when these matters end up in front of QCAT, QCAT's position is very clear. You can't have a blanket prohibition against pets.
Yep. Well said, Antonia. It's virtually identical in body corporate world. Next myth, one of my favourites: the tenant or indeed their managing agent cannot talk to the body corporate committee. And that's very false. It used to happen in my former office where we'd hear body corporate managers say that, and I was just gobsmacked. And it's little wonder, Antonia, isn't it, that your members would be struggling with things when they get that kind of reaction?
Yeah, absolutely. And it's sort of one of those curious things where you wonder what its origins are and where it's come from. But and it flies in the face of reasonableness, because that communication and openness is really key to success in this area.
Absolutely.
And
Frank?
it's that battle, isn't it? It's sort of the body corporate managers not wanting to deal with a tenant, well, with a representative of a tenant. We're speaking before about advocacy in relation to that leaking roof or whatever it might be. It's not, I suppose, traditionally part of your services that you've got built into your Form 6, but and it's that battle, and I suppose part of it too, Chris, and this probably feeds back to what you're doing with the SCA at the moment in terms of whether there's going to be some licensing regime for body corporate managers, because at the moment there is none. All three of us can go and become Frank Higginson Strata Management tomorrow without any trainings, qualifications, experience, or otherwise. And I wouldn't do it for IT in China. But it's that sort of, and it can become the blind leading the blind. You know what I mean? And there's no there's a traditional career path for lawyers. There's probably a less traditional career path, but very understood one for real estate agents. There certainly isn't one for body corporate managers.
What do you think, Antonia, while we're on that topic? Let's kind of keep going with that one. I mean, real estate agents are probably the most heavily regulated profession imaginable. I know, because I used to draft the laws for that. What do you think about body corporate managers from the experience of a very heavily regulated profession? What will work, what won't work?
Look, I think from our perspective, given the subject matter that they're dealing with and the significance of it, I actually think it's completely reasonable to expect that there should be some educational qualification, some sort of minimum educational qualification around it. To your point, Chris, real estate is very, very strictly regulated. Consumer protection is very much at the heart of the legislation governing real estate agents. And frankly, I think there's good reason for that. And again, we're talking about where people live. So the need for strong consumer protection is well understood, and I think well justified. Although having said that, I do think the Property Occupations Act goes too far in some areas, but that's for another day. But in terms of what my position is on this, I think I am stunned that there is not a requirement to achieve some sort of educational qualification and some sort of ongoing requirement for ongoing training, because this is a complex area and changes are occurring on a daily basis, and it worries me that anyone off the street can come along and basically start a business in this area with no experience and no knowledge.
And with a lot of funds at risk as well, potentially.
Exactly.
Well, a couple of big rorts over the years, and it's never turned into the political football that, dare I say it, Antonia, a real estate agent or a lawyer's trust account would be.
Yeah. And I think that's what we've got to understand. I mean, I think real estate agents and lawyers, as you mentioned, Frank, we have a fiduciary relationship with our clients. And of course, when it comes to trust accounting, the legislation governing trust accounts is incredibly militant and very strict, as it should be. And so it beggars belief that hasn't been expanded to cover this sort of activity.
Yeah, absolutely. And interestingly, just looking at the comments, and there's plenty of them coming through, pretty much all in favour of the idea that body corporate managers should be licensed. But a couple of qualifiers chucked in there about ongoing training. The Cara, hello, as always. The idea about self-managed complexes. What do you do if there is no body corporate manager at that? How's that going to help that particular one? An excellent point. One more kind of myth/area before we get into some sort of practical tips for everyone is this idea that when you're a tenant in a body corporate and you're experiencing a problem, be it bylaws or, say, maintenance of common property, where do you go to get that fixed? I've heard so many times as commissioner and in this role where the body corporate refers the tenant back to their agent. I've also heard the flip side as well, where it's the body corporate saying that they must engage with the real estate agent to try and get a result about a tenant. And that's usually in instances where the tenant is breaching a bylaw one way or the other. I might throw to both of you on this one. I mean, how do you work out the best way of getting the best outcome in those situations, Antonia? Do you think?
Well, I mean, look, I'll leave Frank to give the legal answer, but I'll give you, I guess, just what I see as being the common sense answer, frankly. I mean, I think so many disputes come down to, prevention is always better than cure. So I think good communication between the parties is always something I will advocate for. I think it's in a real estate agent's best interest to have a good relationship with a tenant, and to have a good relationship with the body corporate manager and committee. So, I mean, I'm always about good open communication, obviously always working within the parameters of legislation. So, I know that there'll be some real estate practitioners who might take a different view, but I think if you want to build a good, long-standing relationship, then trying to be reasonable and communicate and understand what's driving people to take to certain positions and looking for solutions is always an approach that I'm a fan of.
I agree, Frank.
Yeah, and it's sort of, this is one of the, I suppose, benefits, as Rama would say, of the management rights model, in terms of the people that are managing properties that have difficult tenants are actually living with them themselves. So it sometimes makes them a little bit more accountable in terms of their relationships with their committee, and also their relationships with their fellow occupiers of that particular scheme. And it's always worth, that bylaw one, mate, comes up a lot, particularly management rights. We've got someone playing up as a tenant. It's not really in the role as caretaker is to really report breaches of bylaws to the committee, which is, for the committee, is the only one that can actually enforce bylaws. And then this is one of the difficulties in a management rights situation is, well, if the owner of the property is in the manager's rental pool and the owner isn't inclined to do anything about the tenant's behaviour because they're getting good rent, we can't find others, we're in a COVID period, what are we doing? You've suddenly caught in that invidious position where you want to do something about it, but you can't, because the only thing you can do about it as a agent is to effectively issue breach notices and all those sorts of things, which if the owner doesn't instruct you to do, you can't do. So, but mate, like we say all the time, it's the communication's 90% of the battle here. And sometimes people just aren't going to behave.
I really like that common sense approach that you mentioned, Antonia. I think that's right. I think where there's ambiguity, you go back to first principles and you go back to a step-by-step approach. Okay, here's the problem. How do we unpack it and how do we arrive at a solution? And the most obvious first step is that you get the line of communication. If you're the agent, pick up the phone to the body corporate manager, vice versa. If you're getting a wall of resistance, okay, you can't do anything about that, but you at least make the effort to weave your way through, and between or amongst all of you, you should be able to cobble together a solution that enables people to move forward. It's those situations where you can't move forward and things are stuck and you've got inertia about a problem. It festers and grows. That's how things are in a body corporate. Once the problem...
People even knowing that there are bylaws.
Yeah.
And what those bylaws require. And this is occupiers as tenants probably haven't even seen them. Like buyers don't see
me, for example, Frank, one of my favourite stories, I am an occupier in a community title scheme and my agent has never shown me a copy of the bylaws. I even asked for them once and they said, don't worry about it, it's just parties and stuff. Yeah. They knew what I did for a living at that point too. Anyway, it's one of my favourites, that one. Anyway, but it's all good. Just conscious that we are, gosh, time does fly on this, doesn't it? I just want to quickly acknowledge some of the comments that have coming through. Rob, thanks for tuning in. Rob, mandatory training for committee members not viable, but mandatory annual training for agents is given. Agreed. Thanks Milo and Philip for your comments. Agree that there is some unrealistic expectation setting that goes on there. Guy, as always, frequent flyer for our webinars. Good comments as always. I just want to pick up one comment there from Karen at the end, who talks about if a body corporate manager is a member of the SCA, the Strata Community Association, they do have a CPD requirement as part of membership and an ongoing training component.
REIQ, it's a voluntary organisation, but that's
that's right.
Yep.
And as you well know, Antonia, that's the way that you get members focused on this idea of continuing to deliver in an environment where things are ambiguous.
Yeah, absolutely. So to be a member of the REIQ, which is obviously voluntary, we require our members to do 100 points of CPD every year. And I've got to tell you, I have to wonder about real estate practitioners who are not members of ours, how they're keeping their knowledge up, because it feels like every day something is changing, and it's just so critically important to keep on top of so many things. And I think I think, you know, again, without sounding like a broken record, when we consider the significance, we're not selling you know, a pair of shoes here. We're selling or leasing property. It's just such an important, it's arguably one of the most important functions in our society. So I think being well educated and having a requirement to keep your knowledge up to date, it might feel onerous, but frankly, I think it's entirely reasonable.
Oh, I couldn't agree more. Could not agree more.
From me.
No, just in the short time we've got left, I had a section reserved for best practice, but interestingly, we've already covered it organically, which is that communication, practical approaches, particularly where things are not clear. Everyone who's watching this telecast might know that real estate legislation is akin to body corporate legislation. It's about that thick. And yet within that, there are so many places where it's not certain. It's left open for you to draw your own conclusions. So where that happens, you need a process to work your way through it. Common sense, logical, practical approaches. Probably the other thing that I'd say, and I'm sure Antonia and Frank, you've seen this a lot, is the idea that you do not hit the nuclear button straight away if there is a problem.
I was about to say that, mate. You're straight on it. We're very
thank you.
tuned. Yeah.
It's this idea that as soon as there's a problem, you pipe up and you say, well, I'm going to fair trading if it's real estate, or I'm going to the Commissioner's office, or I'm going to the RTA. You never lose your right to do those things, but you always keep those as a reserve power. I mean, Antonia, your thoughts?
Well, I'm smiling because I'm often CC'd on things where it's like people think if they CC me, they'll just somehow miraculously fix something. Yeah, look, I think, look, as a former lawyer, you know, we do interesting things as human beings when conflict strikes. And I think, you know, it's interesting because, you know, as a former lawyer, there were so many disputes that I would look at and I'd shake my head in disbelief that it had grown to the stage it had grown to. And, you know, for me, you know, I know I've said it a number of times already, but, you know, communication is key. Don't just immediately threaten to go to the Office of Fair Trading or go to, you know, it's easy to say those things in haste. As you mentioned, you've always got those things up your sleeve. You can always revert to those processes, but you should really see that as a last resort, in my view. And, you know, almost all things can be resolved if you're prepared to sit down, understand what that person is looking for, what's motivating them, you know, just the simple process of asking the question about why is it that you want this thing, or why is it that you're upset about this thing. And if you give that person an opportunity to explain that, in my experience, you can usually find, you know, a solution to those things. So, you know, I'm not saying in all cases. Sometimes there will be, you know, people will be unreasonable, or it might be impossible. But certainly your starting position shouldn't be that.
Frank?
No, a lot of people's is. And I remember, Chris, even well, over the years, how many times was the Commissioner's office CC'd in on body corporate complaints as if you were the police about to go knock on the door and sort something out? Yeah, it's no, agree. And, you know, we sit here and say these things, but people do get entrenched. And one of the things we're trying to do with these webinars, and Chris and I had a session with a client this morning who has been watching these and has basically changed the way they were reacting to nasty emails, which has watered down the pain. So it's actually, those little things for me are rewarding, the sense of it's getting through, because their lives are now better through a bit of educative content, which is what this is.
Yeah, absolutely. We just about reached time today. I think we could continue this for hours endlessly. Yes. But I think maybe a part 2 sometime, Antonia, if you're up for that. Sorry to put you on the spot. But a part 2 sometime would be great. And maybe what we could do is take some specific questions from your members next time around, sure. and likewise from the body corporate world as well. I think that's a really good point to finish on, though, the idea that you have to actually hit the pause button, whether you're a real estate agent, whether you're a body corporate manager, whether you're a committee member. It's not all stressful. It's stressful a lot of the time. You get a lot of things coming at you. To hit the pause button and be able to reflect and then reconsider the better outcome, it means everything to going some way towards getting through the issues. Thanks to everybody for tuning in today. We had some great questions and great comments today. This will be available on the Hines Legal website as a recording, and I dare say it's going to be available through the REIQ as well. Antonia, excellent. Antonia, thank you so much for taking time out of your day. I'm sure there are many other things on a Friday afternoon that you could be doing. Really appreciate it.
None as enjoyable as this, though, Chris.
That's fantastic. Thank you so much. Frank, as always, you're obliged to be here, so it doesn't matter. For everybody else who's tuning in, again, thank you for tuning in. Please don't forget to like and share, and we'll try and get to other questions on the Facebook page. We'll see you next week. Thanks, everyone.
Bye.
Bye.
See you.